Then we'll go to module 1, summative. We'll then do module 2, formative, module 2, summative. And we do things like that in order. And Kotato is here. She will help me to, okay, same on the emails. That makes things easy for me to navigate. And I'll put on screen for you for module 1, so that you'll be able to see what I see and we all go through the same thing. Let me share. Okay, I have to open it first. Module 1, summative. It's now open on my side. And I have to find formative as well for module 1. Sort you out now. Let me share then my screen. I should be on. Thanks, Mel.
I was really expecting him because nobody on the said that they're coming. So
Okay, online, tell me on the chat group or something if you are able to find the assessments. If you're not able to find the assessments, we have to make sure that they get to you somehow, either through a... Okay, let me see if I can put something here. What happened to my attach feature? Because now there I was confident that I'll be able to attach for everybody and pops your uncle and everything is good. It will be done. So, I'm not able to get you there. So let's see something else. Let's try plan B. If plan D fails, we'll try plan C. If that fails, we'll get our pilot to fly over to your houses in a chopper and drop off one at each house. Okay, I'll ask Merlin to email them to you quickly in it will be in Wait format. Hi, welcome, welcome, welcome. How are you? Good. Those in class, are you able to get the assessments on e-leader? Then you also log on your e-leader. I think I have. I'm logging onto e-leader to see if you guys see what I see. If they're there. E-leader. Let's go to sites. I've got a lot of sites, so I have to find your site. Should be Paralegal. Okay, give it a little while. Madeline will email it to everyone so that you'll be able to get it on your emails then. Once you get the email, please indicate by thumbs up on the group or say something on the chat, or you can also unmute yourself. We talk. It's activities day anyway. You do all the talking, I do all the listening today. So in class, you can get pack here on that table. So you should be able to find assessments, formative, summative. It will say module 1, 2, it's there. Yeah, you can pick them. Just check if, I think she's printed them separately. So you check if you're getting one of module 1, module 2, module 3, module 4. So if you got this right, you should be having 8 assessments. 2 for module 1, 2 for module 2, and 2 for 3 and 4 respectively. Online, we're trying to get these emailed to you so that you'll be able to have them. And then we can have a discussion around how to complete them in the next 10 minutes. So We don't.
Hi, Mr. Paul. I hope you're well. I got my email.
You got the email. Thank you. Please open up those, all of them, save them in some folder on your computer. And we'll start with module 1, then move for summative and then formative. So when you save it in the folder, perhaps create a folder called assessments. In that folder, create another folder, call it formative, and then create another folder, call it summative. In the formative one, all right, so everybody's got the assessments. I'll try and share one more time. So you should be looking at formative assessment, introduction to law, formative assessment. It should be formative assessment 1. But what you're looking at is the entire cover of the assessment instrument. So the second batch you get, it will just be a continuation of this. Like, so you're having question 1 that says true or false. You having question 2. I'm scrolling fast though. I'll come back if I'm leaving you behind with my scrolling. Question 3. Question 4. You should have ended somewhere at 10. that says multiple correct answers. We're having the same thing. In class, does this show the same thing? Does you end up at number 10? Question 10 should say multiple correct answers on module 1. If it doesn't make sense, you can bring it to me. I'll show you what I'm talking about. So if you were to open this, the last page, which module is this now? Introduction to law. Yours is 17. Is this summative? Get the formative one.
Okay.
Yes, check there. Do you have the formative assessments there? No formatives. Okay, let me ask Petaso to bring in the formatives in class. Kotas will bring the formatives now. So for you to see then what I'm talking about, I need to get you connected like the guys online. I'm talking to the guys in class who don't have a formative. You guys online have a formative. So I'm now connecting a projector for them so that they can actually see what we are talking about. So I'm going to repeat the whole thing so that everybody can see what we are at. So in class, you don't have this. Online, they have this, but if you're having your computer, you have it on your email, actually. And you scroll through, you'll be able to see where you put your personal details and IDs and everything. That is the cover of the actual formative for module 1 in general. So if there's anything that's going to be added, it will not necessarily come with this. It will come with the next question. Like, if I'm not going to question, this is question 1. So I'll scroll further, you'll see question 2. And I'm going to scroll very fast so that I can go to the end, and this will be 10. So if I add anything else, I'll email you something or print you something, and then when we do another interactive session, that will say 11, 12, like that. But it will not come with a heading like this, right? It will just be a continuation. So how we're going to do these assessments, we're going to do the assessments in batches. Make sure that you do a specific portion, you finish it, you do the next portion, you finish it. I will not tell you to submit them yet. When I need you to submit them, I'll tell you that you have now reached question 10. Please submit the batch. Then you submit the batch either on eLeader. How you submit on eLeader is the things that I need you to write by hand. I'll tell you that these write by hand. So at home, you'll print it, you'll write it by hand, you'll scan it, and you load it for me on eLeader, and you send it through, and keep the original. Thing is, these are SASITA assessments. They prefer assessments by hand in paper. So when they do verification, they're going to do a paper verification. I'm still convincing them to do an online verification though. So should we agree that we go with online verification, I'll tell you, do the assessments by hand, keep it at home. So how do you keep this best? Buy an ArcLever file then. When you print them, put them in an ArcLever file and have separators. So have the first separator, you need like 8 separators because you're going to do 8 assessments. The first 4 will be the formatives and the next 4 will be the summatives. So the formatives will be the ones at the top if you're separating your folder, and the summatives will be the one at the bottom. So if somebody's going to ask for your file at a later stage, we are going to add new things in that file. Before we finish the course, I'm going to email you something called a verification pack. A verification pack will contain the things you need to attach in the ArcLever file. So those things will include You need to put the copy of your ID, previous qualifications, and things like that, a CV, and all of that. I'll help you through with the process. Don't worry about it now. So it will also have a table of contents. We'll sit together like this in the interactive class and say, this is the table of contents. If you're in class, here's a copy. If you're online, print it. Now, put a copy of your ID. We'll do this when we are preparing the file, and then the file will be complete. I'll then give you a week to bring it in. If you are anywhere near our centers, I'll tell you where to drop it. If you can courier it, I'll tell you how to courier it and bring it to us. Otherwise, you can drive through and bring it to the Law Society, or you can also bring it to my office. I'll make you coffee. So there you are. Here, you simply put your names and details, and all of that is the admin work we'll do at a later stage. So for formatives, you are able to do formatives as group activities, which means in class, we can sit and debate whether the question for number one is true or is false. If we agree it's true or is false, we then is true. Or if we don't agree, you can go with your own answer, or we can vote. So I'll help you to do, for you to go with question 1, question 2, up until question 5. And the rest of these you'll do on your own. And when you're doing on your own, you realize that your WhatsApp group is not is closed. So I'll ask them to open it for you so that you guys can interact on your WhatsApp group, and you can do the assessments during the week. You can format, click, and you discuss what to do, what not to do. And if you like, somehow during the week, you can also set up your own Teams meeting to discuss some of these things. The rule of thumb is avoid plagiarism. Plagiarism is don't make one assignment and copy and paste for everyone. With true and false, it works, I think. It's either true or it's false. There's no way to do the other way around. But if you're going to do, I think that works also with question 5, question 4. I'm trying to find something different. And I'm not succeeding here, am I? So let me move and see if I can find something really different. Kotatsu said to me, no, they've got the same format. Yeah, they've got the same format. You see, these are just straightforward. You guys can discuss and complete them as you wish. Generally, the answers will be the same. When you go to the summatives, you'll see that there's also spaces where we want you to write things. So when we want to write things, please use your own words, but I'll discuss that when I do the summative with you now. Online, you also have an email with summatives, and in class, you also have got an email with summatives, right? So let's go a summative. You've got a formative, which I've just shown you. Let's go and look at a summative assessment, what it really looks like. To minimize this, go to my computer.
Hi, Mr. Pala.
Hi.
Sorry, Mr. Paula, we haven't received the summative email as yet.
Okay, you guys sound
Yes,
like
that's
I'm
right.
teaching you from Greece and we're in South Africa. We'll email it to you now. Kontatso is going back to mail and they're emailing it to you. So since you haven't received your summatives as yet, let's do formative then. Will that work? We continue doing the formative until you get an email. Once you get the email, let me know. I give you 5 minutes, you download it, right? So
Thank you, Mr. Paula.
I'm going back to the formative. Thank you. I'm going back to the formative. Okay, back into the formative then. In the formative, this is based on module 1. So you guys have a module 1 in your study guides on e-leader. And if you didn't bring a copy, I don't know if I've got mine here. I can borrow you mine. After class, you can bring back mine. If you're able to find your module 1 and e-leader, so you have to multitask somehow, eh? So to do this, you have to move around the modules and move around the summatives. And so in your module 1, we were talking about theories of legal system. One of the theories of the legal system, they say it's a modernist legal system. You can unmute yourself and let me know what is a modernist legal system. And if you have found the page where it is, you can unmute yourself and say, it's on page what? And then we discuss it. So in this class, you're allowed to unmute yourself, we talk. So you can talk. If it becomes chaos, yes, it is an activity. It's meant to be like us sitting in a room. So check it if you're online, and in class also check it. So I will let you guys find the modernist theory in your book, and then we discuss it from there. What I want you to think also when you're thinking of it is the crux of a modernist theory. It's on belief. If you found it in a book, is it there? I'm not having a book in front of me, so I'm not looking. So that's why I'm asking you. So yeah, you have studied that, you looked through the book, you're now doing an assessment, and I'm giving you a clue and saying, well, that theory talks about belief. So if you're having the book in PDF, you can search for modernist in PDF. So it will take you to modernist and then read through the theory. But Rob Class said the other one. Well, the theory of modernism does not subscribe to religion. Therefore, that theory, when people subscribe to religion, do they really subscribe to you having a good conscience or not? What do you think? If somebody says, I don't subscribe to any religion, does that person say they subscribe to your good conscience, to say you do things that are good or things you avoid things that are bad? No, right? So the modernist legal theory does not believe in a theory of your found conscious. So your answer would be what there on number 1? It will be false, yes. So the right to life is a second generation right. For starters, have you ever seen something called a second generation right in South Africa? The South African Constitution has got the rights. These rights are found where in the Constitution? Online, I'm looking at you. I see you. Please hand me the formative assessment copy. Guys, I need you guys to interrogate these ideas. So if I'm asking you questions, interrogate them, talk, open the mic and say something. Yes. In class, I'm going to switch off the projector. You don't need that screen. You can look at the formative in class so that I can easily navigate the people online and I can see Tineke. Justin, where do you find human rights in the South African Constitution? Or at least where do you find human rights in South Africa? You see, I see you. Somebody says the answer is false. Why? Why is it false? Katleho says you find it on chapter 2. Shimona says on the Bill of Rights. So you guys don't have second generation rights. Do we have second generation rights? Yes or no? We do not have. So Tineke, generally then the answer for number 2 will be what?
False, Mr. Paula.
I agree with you. Hundreds.
I don't think that you can just change the rules as generations go on.
Yes. So you see how these questions are actually set. They test first your attention to detail, and then they go to the concept. So if you got attention to detail, you would have seen that this question is talking about second generation rights. In South Africa, we don't use second generation rights. We actually use the Bill of Rights, which you find in the Constitution, correct? And therefore, if you would say yes, the answer would be no, because we don't have second generation rights. So let's go to number 3. Have you, say to me, the guys online, Nokwazi, do you have a copy of the attorney's code of conduct? Is it on e-leader? Where's Nokwas? Somebody go to Nokwas's house. Ketulo, do you have that copy?
Hi, Mr. Pala. I have not logged on eLeader. I forgot my password, so I think it's going to take a while for me to be able to log on.
Okay. Have you guys, so you think we should also email you a copy of that? You can also find it on the legal practice website.
Okay, sir.
So just get a copy of the attorney's code of conduct.
On the legal practice website. Okay, sir.
Yeah, even if you don't get it today, I'm not really interested in you having it today, but at least for you guys to have a copy. It's written 29 March. It's on Government Gazette number 42364. 42364. Government Gazette 29 March 2019. It's Code of Conduct for all legal practitioners, candidate legal practitioners, and juristic entities. If you come from, thanks, Petolo. If you come from the full-time class, the class that attends in the morning, you should have a copy of this because we were doing this in yesterday's class in the morning, and we were talking about the code of conduct. So if you're attending in the afternoon, like Leanne and others, you need to get a copy. And if you find it, and I think somebody will share it for you in WhatsApp groups at the later stage as well, have that copy because we are going to discuss that copy in our next class when we do the module on professional conduct, module 2. Now, having had this discussion now, look at number 3. Number 3 says the conduct of attorneys is regulated by the Bar Council. Is this correct? You don't have the
No,
copy.
Mr. Pala, it's incorrect.
It's incorrect, isn't it? Because
Yes,
we just discussed that for you to have this, the code of conduct of attorneys, it's regulated by the code of conduct, which is from the Legal Practice Council, isn't it?
that's correct, Mr. Pala.
Yes, thank you very much. So number C is false. What do you need? All right, so let's have a discussion about the answer for D. Talks about the legal practice bill, but then again, the legal practice bill has since evolved into the Legal Practice Council Act, which amongst others, that act, it's about regulating the affairs of attorneys. So if you were to have the code of conduct, and I'm alive to the fact that you guys attending the afternoon class, you have not arrived there yet to discuss the code of conduct, but somewhere in your module 1, you probably also looked at the discussion around what is the law that regulates attorneys, advocates. It's called the Legal Practice Act. It is actually from the bill that's called the Legal Practice Bill. So you understand that before you get an act, you first start a bill, you get a bill, right? And the bill gets signed, it becomes an act. But before the bill is signed, it becomes a green paper, a white paper, green papers, discussions, you end up with a bill. And then you end up with an act. I'm speaking slowly because I'm thinking of this, whether I've shown you this or not. On your notes for module 1, I think I've done that. I have put for you a link which said this is how an act is made. It shows you the parliamentary processes. Do you have something like that? Do you have a link like that in the book? That shows you government, and it says the government passes, the legislature passes the bill and all of those. It links, I think it links you to the Department of Justice. Interesting. You can see in interactive classes, I'm not looking at the book. I ask, now I want you to be the teachers. You know, I must find things in the book. And during training, I'm the one who's doing all the talking in the books. Now you're the ones going to go through the books. Check for me and see if you've got, your book has got some sort of a link like that. If it doesn't, you need to go online sometime, if not today, find out how laws are made in South Africa. I think if you go to the Department of Justice website, you are able to find something like that. They'll show you that it becomes a paper. I don't know which one comes first, white paper, green paper. It becomes a paper first that gets debated in Parliament, and then becomes a bill that it has to be passed by Parliament. And then the bill gets passed, and then it becomes an act. Why am I this very interested in getting you through that whole go search, go find? You're going to find that sometimes an argument in court or would be an argument not in the act, but in what is found in the bill, and to some extent in a paper. When we are trying to persuade the court that, my lordship, whereas there is no legislation, thank you very much, Shimona. Whereas it's now in the chat group, Shimona's just put it there. Whereas we don't have a law dealing with this matter of spatial planning, for example, there's actually a law now, it's called Spumla. But before it was there, this is what we used to argue out. But, well, the bill now before Parliament, which I believe your lordship will now be passed, considers that Spumla does A, B, C, D. In your case, if you're going to talk about this question that got us to this discussion number D, you'll say, well, there's a legal practice bill, which I believe that bill, your lordship, will regulate how the paralegal professional would work. And Petolo, say check page 13 of the learner guide if you want to see the link. So you see, that is a persuasive source of law, even though it's not as strong as if there was an act. So for the sake of D, what would be your answer? After all this discussion. I can see a message from Marilyn says, you find summative assessments on e-leader. So if you're unable to log on e-leader, oh, my friend, somebody should email it to you, but try checking first on e-leader. Monique, what would be the answer for D? Monique, there are only two. Yeah, if you see, if I were you, I'll choose one. So that's what I wanted to say. I'll say, if I were you, I'll choose one. I'll choose true or false, and that's it. I've given my answer now. Okay, so Monique, I've got two answers. I've got yours. I've got Bonat's. So let's go through the two, right? So that you see the thinking. I just discussed with you guys on how an act is formed, and an act is formed by first having a bill. And I've just said to you that a bill that created an act called the Legal Practice Act was called the Legal Practice Bill. So the Legal Practice Bill talked about regulating the legal profession. Now, the Legal Practice Bill, does it really regulate paralegals? At the beginning of our course, we said there's no law that regulates paralegals. Have you seen something like that? But because we as paralegals, we fall within a certain field. What field is this? It's the legal practitioner's field, right? And that bill talks about the legal practice and everybody involved in the legal office. Are paralegals found in legal offices? Yes, Konaza. So you'll find paralegals in the legal offices, right? Hi, ma'am, we are in class. We are in class. Thank you. So if we are in the legal field, what does the legal practice bill regulate? Precious, now that you're volunteering to speak. Precious, what would you find in the legal practice bill? It regulates certain people. Which people? And Shimona says it regulates the, yes? The legal professionals. Somebody says bonus law field. So therefore, this bill covers us, man. So the answer for D will be what? It will be true. Do you see how you found it? You found it by thinking what law affects somebody in paralegals. And it will be the very same law, because even though that bill doesn't say a paralegal. But if you are going to say attorney, it does cover attorneys. If you're going to say advocates, it says advocates. How about their PAs and secretaries? It doesn't say, but it covers them because it says everybody who works in the law office. Okay, so we have moved D, and let's look at E. The Constitution is the highest law in South Africa and reinforced by the Constitutional Court. Which law is the highest law in this country? Yes. The
Constitutional law.
So constitutional law is the highest law. So if you, the Constitution itself says it is the supreme law. So the answer is true. We skip that one very fast. We don't stop there. E, we move. We go to F. Hearsay evidence shall not be admitted in a criminal or civil case unless the court agree to admit to this. The answer to F would be true, right? No complication there. It's generally, remember when I talk about it in class, I said, is generally not admitted. So generally, when you hear the legal people say generally not, it means if you give good reasons, it will. So if you looked at you, and I'm getting into run around looking at the acts. This was discussed in the AKA bail hearing, and they were discussing hearsay evidence. And they said, well, it's generally accepted. But when they're doing the Mapisa Ngakula bail hearing, they also use the media clips. Her advocates use the media clips. She says, well, it is said in the media, this is what. It's hearsay, but that hearsay was also corroborated by other facts. And because it's even a bail application, that hearsay was actually accepted. And hence she paid 50,000 rands. Lucky minister. It's a lot of money, but hey, I think 500,000 would be nice. So the answer to F would be true. So we go to G. A court will grant bail to an accused if the accused is likely to abscond. To abscond, the word for abscond is, what is the other word for abscond? Or the other understanding of abscond? Because that's all one for the summatives as well. Yes, yes, exactly. I see some run away. Yes. I was thinking, flee is very fancy, Shibona, but this guy says they will run away. Yeah, so they don't want people who's going to arc group and run away from this thing. So, what would they answer then? False, right? Correct. And somebody says not attending. Yes, he's not going to come back here. We're not going to give him bail. It's a big issue in bail hearings. So why is this important though for me and you? It's important that when you talk to your client, you need to say to your client, rule of thumb, you're a criminal client. You have to convince the court that you will not run away. So do you have children? Are you working? Do you go to a church? Are you so very close to the children which are with the baby mamas? You need to explain all these things. Say, I visit my baby mama every 2 weeks because I cannot sit without my child. And all of this is important. That the court will say, hey, this guy is very attached to his children. Eh? He won't run away. So that's the thing. So your attachment to the country is very important when we want to determine whether you will run away or not. Where were we? We are now at the age, the action procure, the action procedure. What am I even thinking procure? The action procedure commences with notice of motion. I won't answer that one. I'll skip. You'll find the answer yourselves. Number I. Remember, there are two procedures. Eh? The other one is action, and the other one is application. The application procedure starts with the notice of motion and the affidavits. Definitely not the action procedure. So the answer will be false. Trespassing or creating a nuisance could result in affected person seeking a prohibitory order. A prohibitory order. So the most important thing you need to find there is the word prohibit. What does prohibit mean? Like you said to me, run away. What does it mean in another language? If you prohibit somebody, stop. Yes, don't do it. Stop. So if you want to stop somebody from disturbing your noise, you can get an order that says stop. So the answer for that will be true. Substantive private law consists of law of civil proceed. No. Remember, we said law on the left, law on the right. Before you get anything done, you must follow procedure. That law is called procedural law. And then there will be the facts, like we are saying, this gentleman said, this baby mama story, I got it from the AKA case. And somebody says, he's got children in different houses, but he goes and see the children often and all of that and all of that. He's trying to paint a picture that he's attached to the children. What he was saying there is substance. So that is substantive law. It's not procedural law. So the answer for this will be what? If you want procedure, you go to what law? Giveaway, right? Procedural law. If you want substance, you go to what law? Like that guy saying, I'm attached to my children, substantive law. So the answer for this will be civil procedure. It's a giveaway. It goes to which law? Procedure law. So the answer for this will be false. Yes, Tamia, correct. You get yourselves a 10 minutes break. Is that good? And stretch your feet, get something to drink, but not that one you were using last night. Get something to drink, which is more like H2O, coffee, and nothing added. Don't go back to the fridge. Go to the tap. See you in 10 minutes time. And don't smoke anything green. Yes. So we're back. Ladies and gentlemen, we back live. Well, we were at multiple choice question 2 for each of the following statements below. Select one of the possible answers given which you believe to be correct. A plea in which an accused pleads that he or she has already been found not guilty of the offense and is being charged is known as who now? If I were you, thank you, Tineke. If I were you, just like Tineke, this is what I would have done. I would forget the fancy language and go with the language I understand. So I would say, convict, acquit. No, he should say I've been acquitted. So that would be number 2, right? Yes, that's the correct answer. So let's go to B. Both civil and criminal matters, the Small Claims Court can deal with the following matters. They only deal with civil matters up to a certain monetary threshold. Right? They only deal with civil matters. They don't do criminal matters. Fines are not collected by the sheriff. Doesn't collect fines. Right? The South African legal system makes provision for protection of. We should look at the things that make sense in our country. It's human rights, mistakes, or elections. Which one we protect vehemently? Human rights, right? So that will make number 1 correct. That went fast. Read the following extract from the Constitution. So this tea break works. Whatever you did, whatever you smoked, this worked. Should have these tea breaks very often. Read the following extra from the Constitution, Constitution of COSATU. The aim of and objective of the federations are to fight for workers' rights, security, social and economic justice for all workers. What will COSATU do then? Rule of law, separation of powers, free election. This extract is talking about what? What are those things at the top that COSATU is talking about? It's human rights, right? It's a right to employment. Multiple correct answers. Select only the answers given below which are primary sources of law. So you look at the whole box. Some of them should be primary and some of them should be secondary sources of law. So you said the sources of law is the law itself. So the law itself as in legislated things. So the legislated things you have in your box, you have what? The Constitution, even though it's not a pure legislation, right? And legislation itself. And then you say, how about murder? It's a common law offense, even though you don't find it generally legislated as such, but it's a primary law. So the second one would be what? Murder falls under a group of laws which are primary things to deal with. It's common law, right? If you forget this in an exam or anywhere else, think the Commonwealth of England. So the Commonwealth groups, South Africa, England, Zimbabwe, and all these other countries which speak English. We got our law from England. So this law is then called the common law. So it will always be one of our sources of law. So legislation itself, the common law, the constitution, you agree. But how about the decisions of the courts? You hear people in court saying, in terms of the judgment of Makonyani, this is what. And the court is persuaded because it has to follow its own judgment. It's called the principle of precedence or statistics. So then that there where you're looking at what? You're looking at case law is one of them. There's another one, they say, oh, if you don't know this song, Hey, Life Has Done You Bad, eh? There are two songs in South Africa you should at least know. Ngalagata, you should know that one. The guy who sang Ngalagata has now since passed on. He used to wear sunglasses at night. That's Mendoza. Hey. And then, so if you love cricket, when Sean Pollock used to bowl, then they'll play Ngalagata. And there's another song also, Bosso Kima. And that guy, I think it's also passed on. It's WHP. So when he died, there was a problem with his wife. He had only paid lobola, and the family said, but she's not the wife. But the court says, paid lobola, she's the wife. Actually, paid half lobola, part of it. Hey, dude, you are married. So you cannot pay half and you say, okay, Ish, I don't trust this lady, man, but you know what we are going to do? We are going to pay half, ne? And then I see how things go. I pay the other. You pay the half, you are married. So how do I know? The WHP judgment is the one that confirmed the story. So it's customary law. The rest of things are persuasive sources of law. I've heard the advocate, to me, it was very nice. If I can get a hold of that affidavit, I would love to read. It's a beautifully written affidavit. I must say to counsel who represented Mapisang Agula and the law firm, I'll check which law firm was that. I want to call them and say, hey, you guys wrote a very nice affidavit. The counsel there said something like, well, this is as good as the laws of the French Revolution. That's very nicely thought because you are now thinking codification and the old laws. They're not the law, but they persuade a judge to understand that, well, it goes textbooks and all those things. Journals, we talk about derivatives, for example, law study guides, all of these are persuasive sources that do not qualify as primary sources of law. So what then you have as an answer? Case law, customary law, legislation, common law, and the Constitution of the Republic of South Africa is one of those sources. 1996, is it? Yes. The Constitution is 1996. Now that I'm talking about the Constitution Assembly is 1996, in the chat box, tell me, so are you telling me that the people who voted first, now they're the very first election, so they voted without a constitution? How did they do such a thing? I mean, the elections were in 1994, and the constitution is 1996. So how did they do this thing now? There was a constitution. It was called the interim constitution. So South Africa has two constitutions. There's the first one, interim one, and there's this one, the final one. And somewhere when you're working in your law firms, you would find that if your firm deals with constitutional matters, there will be times where counsel will say, look at the interim constitution and let's look at it. Yes, that's correct. Okay, so let's go to number 5. Multiple correct answers. Select only the answer given below, which are decisions the client must make after consulting with his legal representative in a civil case. So, decisions the client must make after consulting with his legal representative in a civil case, how and when he will be paid by the legal advisor. I am not paying anyone. So, if your answer there is you tick how and when he will be paid by the legal advisor, and now that I am in Gauteng, I would say, and these nigga defy kidnap. I'm not paying any client. So, the number 1, it's a no for me. You say, but wait, Mr. Paul, what if it's a road accident fund claim? I'm not paying. It is the road accident fund that is paying. They put the money in my trust and I'm simply transferring to the client. But the road accident fund is the one that's paying. So legal practitioners don't pay clients. So the first one is not correct. We skip it. If a court is not an appropriate forum, another forum will have to, yes, think. What is another forum you can use in a labor case? You can go to the labor court, but what is the other forum called? Which usually people take their labor issues to, which we encourage you to start there. Yes, honestly, the CCMA is another forum. So number 2, this person is making sense, ne? So we take number 2. Number 2 makes sense. So let's go to number 3. If a court of law is the appropriate forum to take a case to, it's just like number 1. There are situations where some cases do not go to a court of law. Let me see what cases are these, and I'm thinking. Well, I talked to, it's in these divorce proceedings. If your practice deals with divorce matters, you'll hear these stories. They say, we are making a settlement, and I'm trying to get an agreed maintenance amount for the child, the minor child. And I've sent a WhatsApp to the father of the child. Usually it's the fathers who cause trouble. Sorry, gentlemen, but it's always usually the fathers who call this trouble in these discussions. And the lady says, and he blue ticks me, Mr. Pal. Can we take him to court now for blue ticking me? Can we? No, we blue ticked away. We can take it to court for blue tick. But it hurt my feelings, Mr. Pal. I'm hurt, you know. Yeah, but wait, next time we'll blue tick him too, but we can't take him to court. So number 3 makes sense. We can tick number 3 because we can advise the client on the things that go to court and the things that don't go to court. Are we at number 4? Those who attend the morning class have had this discussion when we're discussing the code of conduct. It is in the code of conduct that we as legal practitioners, we must not just take a case. We must tell a client whether there is a case or not. Like the previous answer I told you about blue ticking someone. Is there a case for blue ticking someone in court? You just said no, right? So the second one is just a bonus point like from the previous one. So this one will tick. Yes, we'll take this one. If the client has a case, we'll tick this one. Is something we want to advise the client because we'll say to the client, no, there's no case like that. The manner in which the case will be dealt with, action or application, we need to inform the client on these situations, right? And the client needs to ask and hear from us. So we tick that one. Can the client ask us whether he will plead guilty or not guilty? Is he allowed to ask us something like that? No. We are not in the business of you pleading guilty or not guilty. We're in the business of defending your case, right? If you're defending your case and you feel that you are guilty, go ahead, plead guilty. If we are defending your case and you feel you are not guilty, instruct us to go to court and say, well, you are not guilty and we are defending you. So on this one and these, we are not going to take this one. We leave it out. If you are that very strong, Petro, take it. For me, I about. Which court will hear the case if a court of law was an appropriate? Yes. Think if you're going to write motion proceedings, isn't it you're going to write an affidavit? In those affidavit, you're going to write something like jurisdiction. The honorable, I think in all of them, also in the particulars of claim, do we write something like that? Yeah, so you write jurisdictions. This honorable court has got the jurisdiction. Yes, so you write those jurisdiction issues. So this is correct, this one. It deals with jurisdiction. Let's check the other one. Which judge he would like to request? This is bribery all over it. This one, no. You're not going to take this one. We're going to blue tick this one. This one, no, we don't do it. So let's see. The ones you got good ticks on. You have good ticks on number 2. You've got good tick on number 3. You've got good on number 4. You've got good on number 5. You skipped number 4 that says whether he will plead guilty or not. You didn't take it because you don't like that whole story. So you went to the one that follows it. Which court will hear the case? You said it's about jurisdiction, so you ticked it. The last one, you said, no, we don't want to be involved in bribery and corruption. You didn't take it. So we moved right along to number 6. Case study with multiple choice questions. One more time. Let's see. Let's read the case. It says, Mrs. Smith starts her own beauty salon and employs a hairdresser called Jane. But after a few months, Jane takes some hairdressing equipment home. Vanish, let's see at number 4. 1, 2, 3, 4. If the client has a case, is that the one? We ticked it. We said yes. We'll advise the client if he has a case, and the client needs to ask us whether he's got a case or not. Going back now to number 6. Vanessa, should we go back to question 4? Vanessa says you skip question 4. Oh, yes. Okay. I just like the stories there about Mrs. Smith and Jane. So let's go back to question 4. Let's go back to question 4. Is the whole question 4. So that says skip the whole thing. So let's do the whole question 4. Let's see. Indicate whether the following statements are true or false by ticking in the relevant column. Let's see. Criminal matters cannot be referred to arbitration. What do you think? Yeah, for the labor matters and stuff, which is just generally your civil matters. If it's a criminal case, it's not the matter between the parties. It's a matter between the party and the state. So the answer is true. Paralegals can work in advice offices, trade unions, and true. Number C, our constitution in South Africa is based on the principle of democracy, justice, rights. True. Number D, a doctor can claim Professional privilege for confidential communication with his patients. What privilege is related to a thing, it's not related to everything. So think of it this way. If you are sitting with a client, you're a paralegal, an attorney in a law firm, the client gives you, think of your weapon of trade, né? He gives you information. It's the discussions, you guys talk. And whatever the client has talked, has said, it is privileged because he came to you in your professional capacity to talk, to communicate, to have a discussion. And that genie box is closed. Nobody can open it. Opening it is unlawful. But the client goes to a doctor, and the client visits a doctor to do what? To get medical assistance, right? Do they go to a doctor to talk? They've got a right to remain silent. So they must just point to the wound. They say, and then say what the wound is about. So they can't do that with an attorney. So they cannot come to you and they say, go and represent me. I've been injured. And they point at the wound. They say, they can't. With you, they have to say, Esh, you are born a male. I was in a gunfight with the other guys. We were fighting over that money we stole. We are both. And then Sipo shot me. They don't have to say this to the doctor, by the way. The doctor needs to keep privilege over something else. And then they say to the doctor, hey, yes, doctor, I also have got asthma. Can the doctor go and tell everybody that this guy's got asthma? He can't. Can you see that the privilege of the doctor is only limited to asthma, but has got nothing to do with who shot him? The doctor can tell that he was shot by Sipo, but the doctor cannot tell that he's got asthma. So the crux of this question is for you to identify professional privilege, underline the word professional. It is linked to your profession, what you do. As an attorney, it's linked to the things you consult when you speak, communicate. But with the doctor, it's got nothing to do with the communication. It's got everything to do with the what? With the type of illness, malady, or disease the person suffers. So the answer for this one, after mentioning this whole story, it will be false. It sounds very true, right? That the answer to this will be true. But the true answer for this is false. Because the issue about the doctor is not the communication. The issue about the doctor is medical records, which are confidential, not Usipo Ntuli. So the correct answer there would be false. It's a tricky one, eh? At number E, a judge at the North Gauteng High Court must follow the decision of a judge in the South Gauteng Court. It's not something it's not something you study a lot in your paralegal discussions. But if you marked it true, I will mark you correct. If you mark it false, I would first find out whether South Gauteng and the North Gauteng have concurrent jurisdiction or not. And Tineke says High Court is High Court. And what about the Western Cape one? Okay. Now that I do commercial law, let me take you to the commercial stories. There's a case in I think it's in the Western Cape, and there's cases in Gauteng, I think in the South one. In Gauteng, they say something about the directors of a company. The director of a company serves at the behest of the shareholders, and if the shareholders of the company at an AGM get rid of the director has got no recourse. The South side, Gauteng and them, they say no, that director has got recourse. You can actually challenge that removal. And the Cape says no, you cannot change the removal because it serves at the behest of this. It's two conflicting judgments. And if we're having this case in Western Cape, we follow the decision of the court in the Western Cape. But we are having this decision in Gauteng. We'd have to follow the decision in Gauteng. But if you're in Gauteng, in Johannesburg and Pretoria, those courts have got concurrent jurisdictions and their decisions are similar. My answer would have been true. After I've told you the story, what is your answer? Because it is the High Court, is bound by its own decisions. And terms and conditions apply, but it is the High Court. I'll go with true. If they would have put a different court, if they would have put, and I can tell you in your memorandum, the person has marked that the correct answer is false. And where they're getting it wrong is if they would have put, for example, a judge at North Gauteng High Court must follow the decision of a judge at the Western Cape High Court, I would agree with them. Also, the answer is false. But the moment you put North Gauteng and South Gauteng, those courts are the same. They use something called concurrent jurisdiction. So to put it very simple, if I want to sue a person in Midrand in a higher court, where do I sue them? I can either sue them in Johannesburg or I can sue them here in Pretoria. Same court. That is why the word concurrent jurisdiction. Well, since I'm marking these things, make up your mind. So if you put false, I'll mark it wrong. But then again, I'll give you the benefit of the doubt. Everybody gets a point here. A point for you, a point for you, a point for everyone. So this I'll mark it right or wrong depending on whatever you say. But for our discussion in class, the answer should be true. For the memorandum's sake, the answer is false. And I get what the person was saying, but he got it wrong. Case law in South Africa is a less important. The moment you say it's a less important thing, we're not going to. We're not going to listen to this. We'll go false, right? Yes. Yes. Next time we'll do a car for you, a car for you, and a car for everyone. For now, we just give points. Guys on the group, they're crying, they're laughing and saying, okay, so you're giving out points like we are Oprah. Yes. Our favorite person. Okay, so we move on to. We've marked that one false already, isn't it? So let's move on to the next one. The accuser in the special court is called applicant, the plaintiff, applicant. Does it really matter? Why? Okay, let me help you with the story behind the plaintiffs. Nah? It has got nothing to do with the court. It's got everything to do with the process. So if you were to do an application procedure, you remember? You write a notice of motion and an affidavit. That's application procedure. Since this application procedure, the person becomes what? Become the applicant, right? So, but no. There are issues that needs to be discussed. We must call witnesses. We are not doing the application procedure now. We do the other one. So if you're going to do the action procedure, we are not going to apply anymore. The person becomes the plaintiff. Now, if you go to a special court, the situation is you're going to call witnesses and all of those. Are you going to submit an application at the special court? No, in most instances, you submit that application, I think, in points in limine, but it's always going to be argued by witnesses and things. Special courts, think of it like small claims courts, maintenance courts. There'll always be witnesses those there. So the plaintiff will always be there, not the applicant. You don't always do application. You always do plaintiffs. Then applicant, always remember, you must apply. To apply, what do you need? An affidavit and the notice of motion. To go to the special courts, no, we bring our klachte at that court. At that court, you're not going to bring affidavits. We're going to come there and say, he took my car. He never brought it back. I want my money. So we're going there in person, plaintiffs. By the mid-1980s, the South African legal order was in a serious legitimate crisis. Kotatso, Star brought me a very nice cappuccino from Mother Kappa, they say. But this cappuccino, you need to put it somewhere in the microwave and make it a little bit hotter, please. I told you guys must come live in class. You sit there online. Okay, so by the mid-1980s, the South African legal order was in a serious legitimate crisis. Yeah, 1980s, think. When did South Africa have some sort of legal order? And somebody told us that when there was a crisis of whether we vote or we don't vote, we even fixed the crisis by making an interim constitution. We fixed that crisis in what year? That's all left. But when I asked when we voted, she said another year, 1994, right? So to figure out whether there was a crisis, it must be to avoid a crisis. We avoided it in 1994. So crisis is 1994 backwards. So 1980 crisis, right? Yes. So the answer for this one will be true. Because we want to say certainty in our country came after we voted and we all had a constitution, an interim one, and in 1996 we made it a formal one. All right, so let's move right along. Thank you, Kutazo. We are now going to which question? She said we love doing number 5, so let's go to the hair salon at number 6. Question 6. Wow, we're actually moving right along. It seems like the end of this session would have really completed up to 10. Let's see. Okay, Mrs. Smith hired Jane. What did Jane do now? Jane took Mrs. Smith's equipment, hair dryers and and stuff. She took it home. What night? Ah, Jane. Somebody said we skipped I, so let's go. The answer for I, if a certain practice is common, back on question 4. Why is it that we skip things on question 4? Maybe we don't like this question 4. We should delete it. This is question 4. I in question 4. If a certain practice is common in a region, it can give rise to no. The answer is false. And thank you very much, Petulo. You know, Petulo, by making me think of I, you are making me think of some case law in customer protection law. In customer protection law, there's something they discuss there. They say, this actually comes from law of contract, actually. They say in law of contract, that which is binding in law is also binding as a result of a hardened custom. Now, a hardened custom is not customary law. There's a difference. Custom is what we do regularly. Customary law is from indigenous law, the lobolas and other things. But custom is, in Zulu they say it's a what? It's trelo. Is it Zulu? It's trelo siyayeyisa ingondo. So this is what you do regularly that becomes a norm. Yes, it becomes a norm. So you find custom from a norm. It hardens into a norm. So a custom hardens into a norm. In contract law, a norm or a custom is binding. But you are having a problem here to say in I, if a certain practice is common in a region, that practice is not customary law. That practice is a norm, which is a custom. So the answer for that is false. It's not even common law. Common law is something else. Like I said to you, the law of England, think, Commonwealth, and then common law. Interesting enough, the reason we put that question there is because common law actually gets derived from custom, gets derived from what happens through the years, but cannot be said that a region makes common law. No, it makes a custom, but not common law. Can we go to Mrs. Smith now? Guys online, these guys online, they don't want us to talk about Mrs. Smith and the hairdresser. Can you, with the permission of the court, now present the evidence around Mrs. Smith and the hairdressing
Yes,
service?
please, Mr. Paula.
Yes.
Can we go to
Thank
Mrs.
you,
Smith?
thank you, your ladyship. Now on the matter of Mrs. Smith and the hairdresser. Oh, my God. So what happened to our client here, Mrs. Smith? Jane took Mrs. Smith's hairdresser home. Ah, Jane. Mrs. Smith got very angry. Oh, they say here. Jane is now feeling very aggrieved as she actually took it home to practice on. Ah, Jane. Really? If our client, Mrs. Smith, will fire Jane, now will defend Mrs. Smith and say, somebody in the class now is saying, stolen. Yes, stolen property. to take anything from the employer, you need to do what? Inform the employer. Otherwise, you are stealing it. But here's the difference though. How about the laptop you work with at work and custom and usually take the laptop home to finish some work and you bring it back to the office? Is that stealing now? No. Can you see now this thing is somehow? But there's an equipment that ordinarily must be kept at work because now, remember, this is a salon. Even if you are not there, Mrs. Smith would now want to make hair for another client and the hairdresser, the hairdryer is not there. Then it becomes a problem. So let's solve their issues. What are the basic facts of this case though? Jane believes she was wrongfully dismissed. Mrs. Smith believes she has a legitimate reasons to dismiss Jane. All of the above or none of them? If our client is Jane, Jane will come to tell us that what happened to her. She was wrongfully dismissed. If our client is Mrs. Smith, she will say she had a good reason to dismiss. So they are both right. So the answer is both of the above. What law applies? We are talking about Jane, who is an employee. Employees fall under labor law. So the law that applies, Labor Relations Act. This cappuccino is nice. Sure, Star, you are the PA. We can't say you are the man. So you are the woman. No.
Hello, Mr. Paula. I also have a
Yes.
very nice cup of cappuccino that my
Yes.
son brought me. So thank you.
Yes. Cheers. Dilek, yeah.
Cheers.
All right. So we move to C. What court will you take this whole story? Well, CCMA in this group, we've already said CCMA before, but all labor things also go where? To the labor court. So 2 of them, right? So we move right along. What legal documents might both parties need when preparing their cases? Contract of employment, offer to purchase, no. Okay, so let's eliminate. I'll go to the bottom. But it should also help you when we are doing this. I hope it helps you pass an exam and see how I actually answer a paper. I use an elimination method. So you go and say, contract of employment, yes, it's a labor matter. Offer to purchase, no. Both of the above, of course not. Neither of the above. Contract of employment applies. Therefore, we only choose contract of employment, right? So you know you've got this answer correct. If Jane takes her case to CCMA, she will need money to pay the costs. CCMA, no. They don't even need an attorney there. They only will allow you an attorney after application. Application means, yes, Kotatsu is smiling because she was with me in another case, and we stood the matter down. We went to another room and we Googled the Toyota case. We went back. Hey, we nailed the application. Hey, Kotatsu. And the application was given. If they send you, they will send you to CMA, eh? As a paralegal, you would go to CCMA. You can actually represent somebody at CCMA. And you arrive at CCMA and they say to you, no, you cannot represent someone here. You say, pull the rabbit out of the head and say, no, not in terms of the Toyota matter. You now sound sophisticated. I can represent my client after you are done with mediation. Yes, at mediation you can't. But at arbitration, we stand the matter down and you apply. And one of the reasons why, one of the persuading factors why a person must get legal representation at CCMA is if they have been dismissed. People who are dismissed must get legal representation if they ask for it. Any other issue, they can deal with it. Okay, so you will be able to represent somebody CCMA if you're working for a labor organization and all things like that. So if they now need you to represent them, they'll need money, but not initially. They don't need money. So this one we are not going to take. A legal representative, not initially. They don't need a legal representative. They might get one after mediation is done. Like I've now said, you need to make the application. All of the above, no, we've just said that the two of them don't apply. So the proper answer will be none of the above. And remember, you are in the legal field. In the legal field, we always use the thinking terms and conditions apply. If they would have said at arbitration, all the above would be correct. But generally at CCMA, all the above are wrong. Terms and conditions apply. That's all Mrs. Smith told us. Me, I thought there will come with some serious issues here. Mrs. Smith. Now, this thing now, there will be some serious questions, you know. Like Mrs. Smith is answering affidavit, we must now draft one. Could draft one now, fast. Let's move on then to number 7. Mesh the term of the on the left is just matching columns, right? So what you're only going to do is to write the number there. If the answer for A is 2, you simply write 2. If the answer for B is 5, you write 5. So let's go and see what happens. Diversity strategy. It will match with who? Will it match with freedom of expression? Nah, you don't need freedom of expression on diversity. Reasons for the decision, also called constitutional nationality. Yeah, but it's got nothing to do with diversity. It's got to do with nationality. Test applied by the judge. You do diversity when you do employment cases. So that would be what? Employment equity plan, because you are saying every employee in the company is equal, irrespective of the gender, the race, the nationality, and all those other things. Can you see now? Now, when I say it in full, it makes sense, right? That number 6 is correct. That at number 6, employment equity. So what is employment equity? Employment equity is diversity. It says all employees are different, but all employees are the same. What is that thing? They have it in, I think it's in one of the South African preambles or something. They say united in diversity. Is there something like that? United in our diversities. It's one of those South African slogans you get when they do human rights. B, horizontal application of the Constitution. What are you talking about? When you talk about this applies horizontally in the Constitution. You said to me, yes, the Rainbow Nation, Pedro, thank you. You said to me, nationality, for example, number 4, is likely applicable to A. And I said, no, nationality has got to do with it. And I agreed, but disagreed and moved right along. Why was I thinking like that? Because nationality does not apply across all elements of diversity. Nationality is one of them. You've now realized that gender is also another, language is another, nationality is another. So you cannot say it's nationality alone. But there's something that applies in column B. It applies to everything throughout the Constitution and through every constitutional right. It says, when you read that chapter in the Constitution, it says, this Bill of Rights. Start checking if we have a constitution here. This Bill of Rights is what? What does it talk about? You find it in what chapter of the Constitution? Come on, where do you find the rights, guys, in the Constitution? You. Not.
Chapter 2, Mr. Pala.
It's in chapter 2. Can open it for me there. And this one. Chapter 2 of the Bill of Rights. It applies where? Does it apply? My mother has got to wait for this. Maybe I should call my mom at social, which say, hey, mom, the people in the class here don't get the idea of chapter 2. So this is chapter 2. Chapter 2 of the Constitution, mom says it applies dwars dear. It applies everywhere, from the top to the bottom, from the bottom to the top of the whole thing, right? So that's your freedom of expression. Applies everywhere in the Constitution. You see? So that's how you need to be thinking of it. Chapter 2. Thank you. So let me read what Star has found and why I'm saying it applies. So Bill of Rights, it's section 7, chapter 2. It says, the Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic value of human dignity, equality, and freedom. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. The rights in the Bill of Rights are subject to the limitations contained or referred to in section 36 or elsewhere in the bill. But you can see these rights, they apply until section 36 comes to play. Section 36 is called the limitation clause. So that's where the mom's idea that says, hey, it applies towards the air. Freedom of expression applies to everything. Okay, so we've moved to B. The answer will be 2. Thank you very much. Shimona, I agree with you. So we move to C. It's 1. Freedom of expression is 1. It applies on B. No? So let's go to C and see what works in C. The burden of proof must be produced by who? By he who alleges, right? He who alleges must prove it is a principle in law. And somebody who says to you, hey, you are now coming to this honorable court to say that somebody has stolen your goat. Now, prove that your goat was stolen. Who will be asking you this question? The person who will be asking you this question is a judge or a magistrate. Yes. So you would have found the answer for C to be 5. At D, ratio decidandi simply means the reason of the court. So the answer for that one will be what? 2, né? Straightforward. It's just the interpretation of that. At number E, you see, when I said to you, it's just the interpretation of that. I nearly said to you, is that the interpretation of that Arabic? It's actually, what language is that? It's Latin. Yeah. So I had friends, they went back home though. I had friends from the Comoros, and it's a small island. So these guys, they would speak Arabic and they would insist, Mr. Pal, you need to learn how to speak Arabic. And then I also had another friend from Egypt. So it's left back to Egypt. So these guys from this, they go back. So it's gone back to Egypt. Now I don't have friends who do teach me Arabic, but I want to learn Arabic. It's one of the beautiful languages to learn. Okay, now move to F. Are we there? Grounds on unfair discrimination. This one everybody must find for themselves. All you should do is to check whichever doesn't have a space, put it right there. That will be 4, right? We are at 5 minutes past 11. What time should we leave, Kotatso? Kotatso says we should leave 11:15. And she accepts to leave at 30 so that she can now rush to the wimpy breakfast in the morning. What time is the wimpy breakfast finishing? Oh, it's the whole day. So make 30. So make 30. So let's finish this 30 minutes whole day breakfast. We'll catch up with the wimpy people. All right. So you are at question 8, so that we get Kotatsu to breakfast very fast. At A, indigenous law is supplementary to public law. Indigenous law is not a supplement of public law. It is the law. So the answer will be false. At B, formal law explains the process in terms of which a matter must. We've already done this question when we did the other one, right? So the answer is true. Remember, the other word for formal law is procedural law. So we move on to C. Local standi is a legal concept for being a defendant in the legal proceedings. No, the standi is the right to be. So the local standi is the right for a person to bring a matter. So the answer will be false. A court of higher status is always absolutely bound by the decision of a court in lower. No, is the other way around. And I'm moving fast on this because some of the things we've already discussed. D, we discussed it when we did the high courts, and you and I said, okay, point for everyone on D. So the answer for this is false. At E, the admissibility of evidence is strictly controlled within the law of evidence. Admissibility of evidence. Therefore, the law would be law of evidence. So the answer will be true. F, the accused is always entitled to adduce evidence of his own good character. And we discussed this when we were discussing the guy who says, no, I go see my child with the other lady and the other child with the other lady. And therefore he's a good guy, goes visit all these people with his children. So he's trying to prove what to us? His good character. He's the accused. The answer is true. You move on to G. The public and legal profession recognizes that paralegals are important because they allow disadvantaged people to have access to justice. I've just said to you that you can represent a person at CCMA. It therefore means that a person like a petrol attendant, a cashier at ShopRite, they can afford justice by joining a small organization or a trade union or something, and then you can go and help them. The opposite applies. The moment they come to an attorney, I represent another lady from ShopRite. The first thing you see, you look at the payslip, and I'm thinking my bill. I'm thinking, sisters, If I really going to bill you, already pay slip number 1, God, it's consultation fee. Pay slip number 2 is me preparing. Pay slip number 3, no, you better off losing this case, game was. So at that stage, you then get attorney saying, we'll represent you pro bono, or I'll only charge you disbursements or something like that. But if the paralegals are there, you guys can assist this at a good, reasonable fee. So the answer to that is true. H, worldwide paralegals have to pass qualifying accredited examinations. It's true. We don't have it in South Africa. It's something that we'll plan to work at. At I, every decision produces an action. No, there are also decisions in court that, like a prohibitory. Remember to me, earlier you said to me, a prohibitory thing says stop. It doesn't get you to do anything. It just gets you to stop doing a thing. So there are interdicts that don't really want you to do a thing. They just say don't do it. Like, for example, case dismissed. It's a decision. The case is dismissed. There's nothing for you to do. Go home, maybe. You can sometimes tell just, so the answer for that is false at I. You can sometimes tell just from looking at a person what his culture, that would be stereotyping. So the answer would be false. You cannot see a culture of a person by looking at J. For example, now that if you looked at me, you'd probably think, that Mr. Pala, Bamba Chivendanga man, that therefore Mr. Pala is Venda. Hey, no, I'm not. Kimubeliwa level. So, mara loko mravula Changani, you think that Mr. Pala, mravula Changani, ba magian, and umiagiane, malevo. So you see, you cannot tell. So, by just looking at a person, you cannot merely tell that he is from a certain area. So let's do the ranking at number 9. How are we doing for Kutatsu's breakfast? We are covering up. We are doing very well. List below are the major steps that will be followed in the mediation process, but they are not in the correct sequence, you know. I am with Tandiwe Kotatso went out, and me and Tandiwe will have a discussion that says, we always say when you do a case, it must have chronology, right? It must be in order. Like, what is the first email they send, followed by the next email? What is the complaint letter? What is the letter of dismissal? How do you get chronology? You use dates. So every time you walk into an office and then they say, can you please help us prepare the case? You know what you need to look for? First thing, don't look for what the letter was about. That's not the issue. The first thing you're looking for is the dates. It came on this day, it came on this day, it came on this day, it came on this day. It is so important that when you do a high court case, before the court can hear the matter, the court will ask for a chronology. It's important. So this question helps you and I to somehow in class do chronology. So let's do chronology. They say telling the story. So the person arrives in the office and they start saying, yo, Mr. Pala, you see, I have a problem. I can't be able to see my child. The father took the child overseas. Is that where we start? No. And then if you're in KZN office, you say to the client, hi, what kind of a person are you? I'll being a lele. So KZN, you'll know this very fast that you missed a step. So the first step would be what? Introduction, right? Greetings, how are you? What's your name? And all those things. So the next step, I will use KZN to help you understand this. So the next step in KZN will be, what is the problem? So means the person will start explaining and telling the story. And in KZN, when you are telling the story, they use the W's. They say, where ma, Why? Where? Everything that is W. Where ma? Why? And then there'll be all those things to explain the whole story. But this will be during telling the story, right? Yeah. You know you're in KZN. So you move to number 3, identifying the facts, issues, and insights. Because when the person is telling, you also want to identify the facts. Okay, Sissy, she says, well, I can't see my child. The father took the child overseas. I also work at the airport booth. I'm telling you, I see people do this thing every day. You say, okay, okay. I hear the story of you working at the airport. Let's go back to your child. Did you give consent? When you're now doing that with CC, you are now trying to shape the discussion so that we go to the relevant facts. Which we say in the airport, working at the airport and all of that. It's good to know, but it doesn't really solve our problem right now. Of course, maybe somewhere we will also say, CC, are you employed? Will you be able to look after the child? Will you be able to take the child? Then she will say, but I told you I work at the airport, Moss. So then the airport now becomes, working at the airport now becomes relevant because it's addressing a particular thing. So when you talk to the client, you're not just listening to the story. You are asking the questions of the court. Like in divorce proceedings, you want to say, all right, so where did you get married? And then you see, we got married in Mpumalanga. Okay, Mpumalanga, which side? The Ndebele side or the other side? What are you trying to do? You're trying to find jurisdiction, right? If they're moving the Ndebele side, it means we are going to the Pretoria regional courts and these courts here. So you have with your marriage certificate, I am now. So this is Pretoria High Court. So if they're saying, in White River, then the situation is now we are in Nelspruit. So you see, you're answering questions in your head while talking to the client. So let's move right along. So the next one, you are also looking at identifying alternative solutions at number 4. Now that you get the facts, you're saying, okay, do we go to the regional court or do we go to the high court? Do you have a marriage certificate? The person says, yes, we're going to the regional court. The person says, no, we're going to the high court. You see? So we're looking at the alternative solutions. That's number 4. At number 5, revising and discussing solutions. And then we now say, okay, I hear the divorce matter. You guys got divorced. The court we are going to be using is the higher court because you don't have a marriage certificate. It's easier if you do this at the higher court. And then you explain all those things along. You say, please, could you please bring me, my brother, your Lobola letter if you still have it? And you still remember who are the witnesses? Are they still alive? If you can check some of them, get me their contact numbers in case we need them. And he says, yes. So that would have done revising and discussing solutions. Then number 6, everybody in the class found out what is number 6. You are right. We reach an agreement and say, we agree now that your marriage was a customary marriage. Yes. You are now getting divorced. Yes. We are filing the paper at Pretoria High Court because you live in Kwamhlanka. Yes. We are now going to have to get the people who were there when you got married. Yes. You'll try and get me the contact details of those people. Yes. So what we are doing now, we are summarizing. When we are summarizing, you hear that we are not doing open-ended questions. We are not saying to the person, where, now that you are divorced, where do you think now we are going to get to issue the papers? That's an open-ended question. The person who says, Minangas, you're in any court. But in summarizing, we are now using closed questions. We're saying, you are divorcing. He says, yes. And because you live in Kwamhlanga, we are now going to use the Pretoria High Court, which is closer to where you stay rather than Nelspruit. Yes? Yes. So we are summarizing so that we get understanding from the client. So that will do number 6. We've got 10 minutes, good, that's all? Yes. So at number 10, let's see if we can get you to multiple correct answers. Select only the answers given below, which are categories of private law. So let's see. Some laws in your book at the very beginning, we said are public laws, but we said some laws are private laws. So let's see, and we said family laws and law of persons. So let's look at these laws and see which ones deal with things done by the government, public law, right? And which things done by you and I having arguments. This will be private law. So this will be easy to find. Constitutional law is done by the government. Me and you will not have to build people roads and all those things. So we skip that one. Criminal law. This would have to be done by the court itself. Unless, remember we said we do law, we have something called, we follow terms and conditions apply. The courts, which is public, would have to do criminal law. But what happens when the court issues a certificate called a nolle prosequi certificate? It was obtained by the former President Zuma against Billy Downer, and he was actually trying to obtain one against Billy Downer and Megan, I think. So he was trying to do a private prosecution. You can have a private prosecution, but you only have it when the public entity says, we are not going to prosecute, and they must give you a certificate called the nolle prosequi certificate. But otherwise, criminal law is public issues. We don't get ourselves some. Family law, we just discussed divorce of a person in Kwamhlanga. So this one is what law? Private law. So this one gets our tick. We'll mark it and say, yes, private law. Law of personality has got to do with me as a person, right? Private law. Public international law? No, this has got to do with whether Israel bombs Gaza Strip and all of those. We feel sorry for that situation, but that situation has got Naledi Pando and the other brass in public. We are not interested in going to court to deal with it. Governments, sort it out. Public international law. The law of persons, whether the child is your child, whether the child inherits from you, private. The law relating to patrimony. Remember the Bear case, BHE. We discussed first thing we came in class. Did we discuss that? I think we talked something about it. The Bear case talks about whether a female child can inherit. So that is private law. So we beat Kotato by 6 minutes. We are good. We are good. We are very good. So that would have concluded our class, which did activities. The next class will probably do an activity for another module. And somewhere in between, I'll show you how to do a summative. Pack it somewhere in the folders of your laptop. Do not worry much about it. When it's time, I'll tell you, we tackle it and I'll show you how. I'll probably help you with one question or so that you get the groove of how to do a summative. But once you get a groove of how it's done, you'll be able to do these as you have done this one. It's quite easy. Thank you very much, Luyanda. Enkosi wetu. See you. You've been itching to go to the fridge, my friends. Yes, attack the fridge and go do other things. And over the weekend, enjoy the weekend. Rest if possible. Go to work on Monday. Thank you very much. Goodbye. And Kotatso, Google nearest Wimpy. Here we come.